Good morning, guys. Good morning. Let me go in and say good morning to the folks up in here. All right, here we go. I gotta put my little echo sensor thing off of here. Hold on, y'all. Just hold on. Hold on. Fixing my little mic thing. You know that little circle thing that they put on? I think it doesn't make a difference, but it sounds like it make a difference. Hold on. I need a new mic, people. This mic here keep falling off. This piece keep falling off. I need a new mic. Terry, I need that mic that you have. Terry, I need a mic. You hear me soliciting Terry for a new mic? Terry, I need a new mic. Brother Terry and 444, I need a new mic. This mic here is not working too well. There's a broken piece here, and I'm gonna have to tape it in here. And I can't look like a ghetto taping thing here. All right. Good morning. Oh, see, it keep falling off. You here? Don't laugh, Terry. I need a new mic. Terry, thank you, Laquitha. Terry, send me a new mic. Y'all, he got a whole bunch of equipment for him to start his channel, and he got stuff that I need, and he needs to send me a new mic. Everybody put in the chat. Terry, send Sylvia a new mic. Everybody put in the chat. Terry, send Sylvia a new mic. Terry, send Sylvia a new mic. Terry, send Sylvia a new mic. Because he's been bragging about all the stuff that he has. Hold on a second. Tanya's coming in because she's going to read to you guys what we got. But we need to put in the chat. Terry, send Sylvia a new mic. Thank you. There we go. Everybody put it in the chat. Terry, send Sylvia a new mic. Because he can't have a good-looking mic. Okay, he put a thumbs up, y'all. Thank you. Thank you, guys, for all the support. You know, teamwork is what make the dream work. Thank you, guys. He's going to give me. He's going to get me. He's going to get me. But anyway, guys, I came on to tell you guys I got my alert today, and there is a motion sent in. And I wanted to bring it to you guys' attention because remember I told you guys anything that comes new, I will bring it to you so you guys can stay updated on what's going on in the court. So this morning, y'all, did I not tell Miss Tanya not to pull anything? Because while we both giving them money and we share information, no, let me tell you what she did. She went and pulled it as well as I did. So that's giving them double the money. That's why our stuff is expensive.
I know. And you know what? After I did it, and right before I did that, I saw you sent me that message, and I'm like, I'm in trouble.
Mm-hmm. I see. She liked giving these people money where she could be.
I won't do it again. I won't do it again.
And it's like, okay, when she does it, I say, okay, let me know so I don't have to pull it. You know what I mean?
I know. But I didn't get a chance to. I guess we were thinking alike because I pulled it and I'm like, Miss Sylvia's gonna get me. Oh my God.
Okay. So y'all, she's wasting money now.
I know it. I'm sorry.
She's wasting money. That's why we have these high bills.
I know, right? Because I'm hard-headed.
Yes, she is.
Sorry.
I'm not going to disagree. But anyway, I'm going to go ahead and pull this up for you guys to see. Just 1 second. And she is going to begin to read it because I don't want to keep you guys too long today. So let's get going. Good morning, good afternoon, good evening to everyone that is in the chat. Sorry I didn't get a chance to one-on-one say hello to everyone. But here's my blanket. Good morning, good afternoon, good evening. Because I say it all three because there are people in different walks of life that is in different continent, different parts of the world, not just the U.S., but hello to everybody. Hello, Mr. Westside over there. It's morning over there still in the Midwest and only Eastern people. Good afternoon. All right, let's get going. All right, this morning I got an alert and there was some motion in limine that was submitted. And I'm not sure exactly what is all this, and I know it's not done by the the defense. This is not motion that was put in by defense. This is something the judge has put in. And we're going to read through this, y'all. Something is going on. Something is going on.
You know what, Miss Sylvia? I think we need to go to page 5, start there, because at the top it's a bunch of just legal jargons and different cases. But if you go to page 5,
Well, don't you think we need to at least read
yeah,
the beginning, just the top
yes,
part? Okay, so they'll
yes,
know what we're doing. Okay,
yes,
hold
yes.
on, guys. Let me just share it with you guys so you guys can see this. Just 1 second. All right, here we go.
Okay.
We're just gonna do this first part, the first
Page
up to here, up to here, up to here, up to the prior trial. Okay.
Okay.
All right, here we go.
All right. So the defendant was charged with racketeering in violation of 18 USC 1962C and 1963. 3 counts of Mann Act transportation to engage in illegal sexual activity in violation of 18 USC 2421A. 3 counts of Mann Act coercion and enticement to engage in illegal sexual activity in violation of 18 USC 2422A. 1 count of Mann Act coercion of a minor to engage in illegal sexual activity in violation of 18 USC 2422B, and 1 count of Mann Act transportation of a minor with intent to engage in illegal sexual activity in violation of 18 USC 2423A ECF number 43. On September 27, 2021, the jury convicted the defendant on all counts. Prior to trial, the government filed motions in limine, which the defendant generally opposed. At the final pretrial conference on August 3rd, 2021, and before opening arguments on August 18th, 2021, I ruled on most of these requests, reserving decisions on two of them. On September 27th, 2021, the jury delivered its verdict, finding the defendant guilty of each of the 9 counts charged. This opinion explains the rationale for those rulings.
Okay, I got a question. She said here that she ruled on most of these, but reserved the decision of 2 of them.
2 of them, yeah.
Okay.
So
Okay.
if you go to page 5, it'll tell you what she started.
Okay, we're gonna go to page 5, people.
Is it page 5? Yeah, where it says discussion.
Okay, hold on. All right, there we go, guys.
Okay.
And those who are wanting to know more about it, just inbox me. Not everybody, but just I'll let you. Just inbox.
Good discussion. So, request to admit certain evidence. A, sexual contact with Jane Doe number 1, a minor in 1994. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 1 in 1994 when she was a minor. The motion was granted. So, can we say who Jane Doe number 1 is, Ms. Sylvia?
Yeah, that was Aaliyah.
That was Aaliyah. Okay. So, in Racketeering Act 1, the defendant was charged with bribing a public employee, ECF number 4313. According to the government, the defendant and his associates bribed a public official so that the defendant could marry Jane Doe number 1 as part of an effort to conceal the fact that he had sexual contact with her when she was 15 years old. ECF number 133 at 14. Evidence of the defendant's sexual contact with Jane Doe number 1 was intertwined with the evidence of the bribing and established the motive for it. The evidence there was no evidence she had sex.
I guess they're trying to explain why they did certain things. So it seemed like somebody's trying to fix what the issues that
errors
that they have done. So, ooh, child,
they're doing some CYA. They're doing a bunch of
covering their
CYA.
butt.
So But there was no evidence that he had sexual contact. But anyway, the evidence was
Just a lying individual who came in and said that. Yeah.
they never,
Hmm.
yeah, the that was hearsay. The
Yeah.
evidence was therefore relevant and not barred by Rule 404B, nor was it barred by Rule 403. It was relevant and probatable for reasons just discussed and was no more inflammatory than the charged offense. U.S. United States versus Rivera. That's the number. Evidence shall be excluded as unfairly prejudiced when it is more inflammatory than the charged crime. So
Mm.
B, the next one, sexual contact with Jane Doe number 7, a minor in 1991. The
That was
government,
Javante, y'all, supposedly,
yeah,
because remember, she never had sex, so they can bring that evidence on now from her other videos saying that she Robert never had sex with her. Remember that, guys? Okay, sorry.
yes. And it says the government moved to admit evidence that the defendant had sexual contact with Jane Doe number 7 when she was a minor, and that Jane Doe number 7 observed the defendant having sexual contact with Jane Doe number 1. That was Javante, right?
Yeah, that was
Yeah,
Javante.
okay. Okay. ECF number 133 at 14. In supplemental briefing on this request, the defendant argued that the evidence was needlessly cumulative. On August 18th of 2021, before opening argument, I granted the request in part and denied the request in part. I found that evidence that
You
Jane
just
Doe
broke
number
up.
7, can you hear me?
Yeah, you broke up a
Can you
little
hear me
bit. You
now?
might have to go back. Yeah, go back to the
Okay,
top
I'm
again
sorry. I'm gonna go back.
on August 18th.
Okay. Okay, on August 18th of 2021, before opening arguments, I granted the request in part and denied the request in part. I found that evidence that Jane Doe number 7 witnessed sexual contact between the defendant and Jane Doe number 1 was admissible for the same reasons that the evidence of the defendant's sexual contact with Jane Doe number 1 was admissible. I also found that evidence of the defendant's sexual contact with Jane Doe number 7 was not admissible because it took place before the enterprise began and was needlessly cumulative. What?
But
Cumulative.
here's the deal. Now, you guys, it looks definitely like she is trying to cover her behind because now
Oh
you're
my
trying to
God, she
explain
is.
why you did certain things and you're putting it in documents. So you're trying to
Why is she
explain because
explaining
obviously,
though? Yeah.
I don't know. I don't know. I don't know.
Obviously, she felt
Because
like she needs
something's
to
not right.
CYA.
Yeah.
Something's going on we don't know about. Okay, on September 4th of 2021, the government renewed its request to admit
You broke up
evidence of
again.
the defendant's oh God. Okay,
You
so
broke
on
up again.
September wait a minute, just a second. Can you hear me?
Yeah.
Hold on. Okay. Am I broken up?
You go ahead though.
On September
Now you're
4th,
far away.
on September 4th of 2021, the government renewed its request to admit evidence of defendant's sexual contact with Jane Doe number 7. Can you hear me?
Yes.
Okay, arguing that it was extrudable, intertwined with the evidence the court had ruled admissible, and made an additional proffer that when the defendant had sexual contact with Jane Doe number 7 and other minors, his associates knew what the defendant was doing. ECF number 192. The defendant opposed ECF number 202. On September 9th of 2021, I granted the government's request. Wow.
Why? Why did you grant the government request when you originally said no?
Exactly.
Okay.
The government's additional proffer made clear that the evidence was inextricable intertwined with Jane Doe number 7's account of witnessing sexual contact between the defendant and Jane Doe number 1 and was additional relevant evidence of the enterprise means and methods. Boyle versus United States 556 US 938 946 2009. An association, in fact, enterprise must have a purpose and relationship among those associated with the enterprise. Accordingly, the evidence was neither unduly prejudiced nor cumulative.
But you said that it was prior to the enterprise being developed. So therefore, you got some explaining to do, young lady.
And it says here there was no need for further evidentiary hearing. The parties briefed these issues and had an opportunity to make their argument during the August 3rd of 2021 pretrial conference. Moreover, as stated above, rulings on motions in limine are subject to change as the trial unfolds.
So she trying to explain herself. She did some lots of mistake, I see.
Yep.
Praise the Lord. Hallelujah. Thank you,
Okay.
Jesus.
So C, sexual contact with Jane. So she's doing this for appeal, right? She's doing all this explaining.
Oh, she's explaining because she sees a lot of errors, a lot of problems. So you got some explaining to do, young lady.
Yep.
Because now
C is
she's going back before. Listen to this. This is being done before they even submit a motion. So
exactly
the defendants haven't even. It's like she's trying to check what she did to try to justify some
stuff that she did wrong.
sounds like a new trial to me.
Sounds like it to me. Sexual
New judge,
contact
new
with
trial, new motion. Hello.
everything. Sexual contact with Jane Doe number 8, a minor in 1994. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 8 in 1994. Who's number 8?
Number 8 should be. Come on, y'all, help me to remember who number 8 was. Those are the uncharged ones. Isn't that the one that? No, is that the deceased one?
No. We'll go back and look at that.
Hold on, is that Stephanie? No, Stephanie's name. Guys, help me out here. Help me out. I can't remember who the Jane Doe number 8 is.
Where's my paperwork?
Who Jane Doe number 8? Who do you guys remember who that is? I can't remember.
Hold on, let's see. Jane Doe number 8, huh? Let's see. So I think she's using these names before. Hold on. Superseding indictment. Let's see who.
Okay, Daniel said what she is doing is required by the rule appellate procedures. The appellate court requires trial judge to provide written memorandum explaining the basis for certain trial ruling. Okay, Daniel, thank you for that.
Thank you. So this is required for her.
Yeah, but it's a lot explaining to me. A lot explaining. Look like the stuff that there was done wrong is what she's explaining, huh? I'm just talking from a layman's term, okay?
Yeah.
I know Daniel knows more than I do about this, but Daniel seems like she's touching those areas that there's a problem in, huh? Just asking. Because she's pointing out certain things that she said before, and then she changed it.
Trying to see who Jane Doe number 8 is.
McCain says she thinks that's Haley.
Oh, okay.
Because number 9 is supposed to be Lizette, because she put herself in that book as number 9. So Haley, she said number 8 is Haley.
Okay, so we'll continue. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 8 in 1994 when she was a minor. ECF number 130.
No, that cannot be her, because he didn't meet Haley until 2018.
So this was in 94.
This 2016 she met Haley.
This was in 94, so we'll check, we'll go back. Specifically, the government sought to present evidence that Jane Doe number 8 was at the defendant's concert, and that one of the defendant's associates directed her backstage when she had sexual contact with the defendant. The request was granted. The evidence was direct evidence of the enterprise and its means and methods. To establish an association, in fact, on enterprise within the meaning of 18 USC 19614, the government was required to prove beyond a reasonable doubt, among other things, a purpose and relationship among those associated with the enterprise. Boyle 556 US at 946. The
Hold
indictment.
on a second. Can we get the likes up, guys? Can we get the likes up? We need the likes up. How many likes do we have right now, guys? Can we
Let's
get the
see.
likes up so we get this thing out, please?
187 watching. We have 68 likes.
Okay, let's put a pause for a minute. Hold on. Let's put a pause. Could we get the likes up, please? We should get at least 100 likes up.
Because we've got 4 down, 5 down, and 81 likes.
How many likes do we have now?
I see 87.
87?
91. 93.
Okay, we have 193 people in the chat and only
96.
come on, we got to get half of the likes. We got
97.
196 people in the chat, and this is all the likes we got. Come on, guys.
We have 97 up and 11 down.
That's okay with 11, as long as they hit something.
99. 101.
Let's keep going a little bit more. I know I said 100, but 196 came into the chat.
Oh, so
How many we
now
got
it's
now?
104, and then now we have 189 people. So people are leaving.
We got 190 something.
106.
They think just because they leave doesn't we're gonna stop with the requests.
I think maybe some people are, I don't know. $110.
Let's say 120, and then we'll keep going.
Okay.
How many we have now?
We're at 109.
The ruling concerning the admissible of matters regarding Kelly having sex with Aaliyah was reversible error because Aaliyah was not available for witness. Oh, go! Oh,
The appellate court
thank you, Daniel, for that. Thank you,
may
Daniel.
throw out count 1.
Thank you, Daniel. Thank you, Daniel. Daniel giving us some nuggets. Thank you. Thank you for being
Thanks,
here,
Daniel.
All right, y'all ready? How many we have now? How many we have in the light?
114.
114. No, we need 120 likes. Perspective want me. Hey, PDQ. 114. Thank you, Miss Fat. Hey, Raven.
116.
116. Okay.
17.
Come on, y'all. We only need 3 more because we got 200 in the
18.
chat. Lord have mercy. Now we got 200 in chat. They want this information, y'all.
118. 19.
When y'all come in, hit the like button. Those are going out. Hit the like buttons. Come back in. Thank you, Kimberly. How many? We are still 119?
Yes, ma'am. 122.
Okay. Thank you, guys. Here we go. We're going to go back to sharing this. All right. Here we go. We were at direct evidence. Let's start with that one. Because you said right after granted.
The evidence was direct evidence of the enterprise and its means and methods to establish an association and fact enterprise within the meaning of 18 USC 1961-4. The government was required to prove beyond a reasonable doubt, among other things, a purpose and relationship among those associated with the enterprise. Boyle 556 US at 946. The indictment charged the defendant was leading an enterprise that included the defendant his entourage, and others, and charged that the purpose of the enterprise was to recruit women and girls to engage in illegal sexual activity with the defendant, including by recruiting women and girls at concerts. ECF number 43, 1 through 4. Evidence of the defendant's encounter with Jane Doe number 8 was probatable and probable and of the existence of the enterprise and the way it operated. Thus, it was relevant and not barred by Rule 404B. Finally, the evidence was not unduly prejudicial. It was no more inflammatory than the charged offense and did not rise other rules 403 concerns.
But here's the thing, Tanya. They're saying that the enterprise, Robert R. Kelly brand, was
Only for recruiting
established
women?
for that. But that is totally incorrect because there's no proof of that was the purpose of that.
No. Hmm. Sexual contact with Jane Doe number 9 in 1995. Hmm.
It's his word against their word. There was no proof of anything that was provided.
No, the government moved to admit evidence that the defendant had sexual contact with Jane Doe number 5 in 1995 when she was a minor. ECF number 133 at 15. In particular, the government sought to introduce evidence that the defendant began a sexual relationship with Jane Doe number 9 when she was 17 years old, that the defendant slapped her with when she laughed at another man's joke, that she contracted herpes from the defendant, and that she was told that he had given her herpes. ECF number 133 at 15 in supplemental briefing, the defendant argued that this evidence was needlessly cumulative. The request was granted in part and denied in part.
So this was supposed to be Lizette because she said she was Jane Doe number 9 in her book.
She was 17.
Uh, since when she? Oh, okay, let me mind my business. Okay.
Evidence that Jane Doe number 7 had sexual relationships with the defendant in 1995, contracted herpes from him, and disclosed that she had herpes to him was admissible to show that the defendant knew he had herpes, which was charged in Racketeering Act 8, 12, and 14, as well as counts 6 through 9. The evidence was therefore relevant. Fed are evidence 401, 404B. The evidence was not unduly prejudicial. It was not more sensational than the charged offenses, and it did not raise other Rule 403 concerns. Evidence that the defendant slapped Jane Doe number 9 when she laughed at another man's joke, although relevant, was needlessly cumulative.
So what?
So they ruled that he did have sex and gave her herpes, but they can't prove he slapped her. Basically. So exposure of Jane Doe number 11 to a sexually transmitted disease in 2001. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 11 without disclosing that he had herpes. Jane Doe number 11 told the defendant she believed she had herpes from him in 2001 and that Jane Doe number 11 entered a financial settlement with the defendant, ECF number 133 at 17. In supplemental briefing on this request, the defendant argued that evidence of this settlement should be excluded because the jury would interpret it inappropriately as a concession of guilt, and because allowing the settlement agreement into evidence would send a chilling effect to any future settlements. ECF number 156 at 1, ECF number 164 at 1 through 2, citing Rule 701C, which prohibits a lay witness from testifying basis of scientific, technical, or other specialized knowledge within the scope of Rule 702. The defendant also argued that Jane Doe number 11 should not be permitted to testify that she contracted herpes from the defendant, ECF number 164 at 1 through 2. The government responded that the settlement agreement was admissible under Rule 401, 408. Wow. ECF number 162 at 2. The government's request was granted.
She granted all the government's requests and none of the defendants.
Evidence that Jane Doe number 11 told the defendant she believed she contracted herpes from him was relevant. It was evidence that he knew he had herpes, which the government was required to establish beyond a reasonable doubt to prove racketeering acts 8, 12, and 14, as well as counts 6 through 9. The defendant's Rule 701 argument was unavailing. Jane Doe number 11's testimony about her interactions and communication with the defendant and about her own medical status is not enterprise. Expert, ex, yeah, wait a minute. Let me put this up. Within the meaning of Rule 702, make this bigger. Jane Doe's number 11's settlement agreement was also admissible. It was evidence of the enterprise and its means and methods, in particular the efforts the enterprise undertook to conceal and perpetrate the evidence. Wow. F Federal R Evidence 401. Nor was it precluded by Rule 408. While evidence of settlement agreement to prove the validity or amount of disputed claim is not admissible. Fed R Evidence 408A. The court may admit this evidence for another purpose. Fed R F Evidence 408B. In this case, the agreement was admissible for a purpose other than to prove or disprove the validity of the claim that the argument was meant to settle. Wow. Those are court cases above. As discussed above, the agreement demonstrated the defendant's effort to conceal the enterprise and was thus admissible. Okay, so we're going down to F, sexual contact with Jane Doe number 13, a minor, in 2006. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 13 in 2006 when she was a minor, ECF number 133, at 18. According to the government, the defendant met Jane Doe 13 at a concert when she was 15 years old. He began a sexual relationship with her and directed his associates to arrange Jane Doe number 13's travel to visit him in Chicago. The request was granted. The proposed evidence was direct evidence of the enterprise, its purposes, and its means and methods. It was therefore relevant and not barred by Rule 404B. The proposed evidence was admissible under Rule 403. It was probative of the enterprise and no more inflammatory than the charged offenses. Sexual contact with Jane Doe number 1, a minor, in 2006. The government moved to admit evidence that the defendant had sexual
That's
contact.
John Doe, ma'am.
Oh, John, sorry. The government moved to admit evidence that the defendant had sexual contact with John Doe number 1 in 2006 when John Doe number 1 was a minor, ECF number 133, at 18 through 19. The government sought to present evidence that the defendant promised to help John Doe number 1 with his musical career, began a sexual relationship with him, and directed him to engage in filmed sexual encounters with others.
Do you notice that they didn't put the age of John Doe?
Just said he was a minor.
Because according to the law in Chicago, 17 is the age of consent.
Yeah, but they still call him a minor, huh?
Yeah, but they didn't put his age. See how weird they are?
The request was granted. This evidence was direct evidence of the enterprise purposes as well as its means and methods. The indictment charged, among other things, that of the purposes of the enterprise was to produce pornography, include child pornography, ECF number 43-2. Thus, the evidence was relevant and not barred by Rule 404B. Finally, the evidence was not unduly prejudicial. It was more inflammatory than the charged offense and did not raise other Rule 403 concerns. threats toward employee number 1, and settlement payment to Jane Doe number 15. The government moved to admit evidence that the defendant threatened employee number 1, a talent manager, and that he entered into a settlement agreement with Jane Doe number 15, ECF number 133 at 19 through 20. Guys, sorry, sometimes I have braces, so sometimes these words don't come out right. In particular, the government alleged that the defendant met Jane Doe number 15 through her talent manager, employee number 1, when Jane Doe number 15 was 17 years old, and that the defendant promised to act as a mentor to Jane Doe number 15 in the music industry. The government also moved to introduce evidence that Jane Doe number 15 subsequently accused the defendant of sexually abusing her. The defendant threatened and intimidated employee number 1, causing her to sign an affidavit, falsely stating that she did not witness the defendant do anything inappropriate to Jane Doe number 15, and that the defendant reached a financial settlement with Jane Doe number 15. The supplemental briefing, the defendant argued that the evidence was needlessly cumulative. ECF number 156 at 2, the government request was granted. The evidence showed the enterprise means and methods. Specifically, it showed the enterprise efforts to perpetrate and conceal the enterprise. Thus, the evidence was relevant and not barred by Rule 404B, nor was it unduly prejudicial because it was no more inflammatory than the charged offense. About Jane Doe number 8, abuse of Jane Doe number 18 from 2016 to 2017. The government moved to admit evidence that the defendant abused Jane Doe number 18 psychologically and physically. ECF number 133 at 212, 21 through 22.
But she never testified.
According to the government,
She got sick.
Yes. According to the government, Jane Doe number 18 began a sexual relationship with the defendant after one of his associates approached her at a concert. The defendant then subjected her to his rules and punished her, including physically when he perceived that she had broken them, directed her to write letters containing embarrassing false statements about herself, and directed her to have sex with him and others, which was filmed. The request was granted. This was direct evidence of the enterprise, its purposes, and its means and methods. It showed the defendant's control over his associates and the victims of the enterprise. It also was inextricably intertwined with evidence of the charged offenses involving Jane Doe number 5. The proposed evidence was also admissible under Rule 413 and was relevant to the charged sexual assaults of Jane Doe number 4, Jane Doe number 5, and Jane Doe number 6. Fed our evidence 413. Moreover, the evidence was not unduly prejudicial or otherwise excludable under Rule 403 because it was no more inflammatory than the charged offense. Threats toward Jane Doe number 6 in 2018 and 19. The government moved to admit evidence that the defendant and his associates threatened Jane Doe number 6 in an effort to convince her to stop speaking publicly about the defendant and drop a lawsuit she had filed against him. ECF number 133 at 23 through 27. According to the government, the defendant and his associates threatened to release compromising photographs of Jane Doe number 6. The threats were communicated in person, in text messages to Jane Doe number 6 attorney, and through a Facebook page. The request was granted. This was direct evidence of the enterprise and its means and methods, including.
Oh, they just made a big boo-boo. It was never on Facebook.
It was. Wow. Including the use of threats and blackmail to conceal and perpetrate the enterprise. It therefore was relevant and not improper Rule 404B evidence, nor was it unduly prejudicial. It was no more sensational than the charged offense or otherwise excludable under Rule 403. Alleged threats to Jane Doe number 19 in 2018, the government moved to admit evidence that the defendant directed a former girlfriend, Jane Doe number 19, to sign a non-disclosure agreement and write messages containing embarrassing false statements about herself, and that the defendant made vile threats to her and her family. ECF number 133 at 28. The request was denied. The proposed evidence was needlessly cumulative. Fed our evidence 403. There was other admissible evidence of the enterprise means and method. The government did not explain how this conduct related to the enterprise. Bribery of a Cook County clerk in 2019. The government moved to admit evidence of a conversation between the defendant and his crisis manager after the release of a television show about the defendant and while law enforcement was investigating the defendant. ECF number 133 at 28 through 29. According to the government, the crisis manager told the defendant that he had two people who know a lot and that the defendant should figure out what he can do for them. The defendant responded, "What do you mean, man? Is writing something on a piece of paper and give me what I should tip the bailiff? What should I tip the valet?" Like when my uncle came up here and said, "Rob, the valet guy, he parked the car over there." I say, "So what should I give him?" He say, "Well, 20, 30, $30." I gave him $30. So what I'm saying is I don't know the number. The crisis manager also told the defendant that he had paid a clerk in Cook County $2,500 and given the clerk a burner phone to communicate information, wow, about the ongoing investigation. The crisis manager said, "That's done. You don't do nothing. You don't know nothing." To which the defendant replied, "Exactly." According to the government, this conversation was evidence of defendant's willingness to bribe someone and therefore was profitable and continuity of the enterprise. The request was denied. The proposed evidence was marginally relevant because it went to the means and methods the enterprise undertook to conceal and perpetrate itself, but it was too tenuous to be admitted. The evidence demonstrated the defendant's willingness to bribe someone. There was no proof that he actually followed through. For this reason, the proposed evidence had the potential to confuse the jury and was not admissible.
Hey,
That
but listen to this. Now, y'all know that Daryl Johnson was not brought in by Robert, right? And also, he was a crook. He was a con artist. So how in
yeah,
the world
they
did that,
didn't admit that though.
huh?
They didn't admit that evidence. She
Yeah,
denied it.
yeah, I know it wasn't admitted, but they still saying that there's the possibility that he was willing to do a bribery. You
Yeah,
understand what I'm saying? Okay.
yeah. Let's see. The defendant's 2008 state criminal case. The government moved to admit evidence that the defendant was tried on child pornography charges in 2008 in Cook County, Illinois, and that he tried to influence one of the jurors. ECF number 133 at 29 through 30. The request was denied. The evidence was not relevant to the alleged enterprise. Fed our evidence 401. Moreover, it was impermissible propensity evidence and cast the defendant as a long-time subject of suspicion. Fed are evidence 403, 404B. The defendant's efforts to obtain child pornography. The government moved to admit evidence that Jane Doe number 5 obtained child pornography for the defendant at his direction. ECF number 133 at 30 through 31. The request was denied. The evidence was not admissible. It was not clearly relevant. The government did not demonstrate that the allegations related to the enterprise or its ends. Fed our evidence 401. Moreover, the evidence was unduly prejudicial and potentially confusing, especially given the government's concession that the people in the recordings at issue might not be children. See ECF number 133 at 31. O. Audio recordings of defendant's physical abuse and threats. The government moved to admit two recordings in which the defendant yelled and physically assaulted women, including Jane Doe number 20, ECF number 133, at 31 through 33. In one of those recordings, the defendant berated, threatened Jane Doe number 20. The request was granted. This was direct evidence of the enterprise, its purposes, its means and methods, and of the defendant's participation in the enterprise. The proposed evidence demonstrated the defendant's control over victims of the enterprise and others, as alleged in the indictment ECF number 437 through 9. The evidence was no more inflammatory or sensational than the charged offense, as it was alleged to depict conduct similar to the conduct charged. The proposed evidence was not otherwise.
Hold on a second. One second. Miss Chinky, the boss, this was done by the judge. She's just explaining the stuff that the rulings she's made, and then she's trying to, I guess, Daniel explained it that this is some procedures that they do. So, but
Standard,
that's
I
yeah,
guess.
that's what it was. What it was done for. To me, it seems like people trying to cover their behind. That's what it seems to me because she's specifically explaining certain things and why she did certain things. But I will proceed.
The evidence was no more inflammatory or sensational than the charged offense, as it was alleged to depict conduct similar to the conduct charged. The proposed evidence was not otherwise excludable under Rule 403. P. Jane Doe number 5's text messages. The government moved to admit text messages that Jane Doe number 5 sent to her mother and friends, ECF number 135 at 18 through 20, because the admissibility of the text turned on trial testimony. I reserve decision for trial. At trial, the text messages were admitted without objection. It goes to all the ones. Employee text messages. The government moved to admit text messages of two of the defendant's employees that recount, among other things, their observation of the defendant's interaction with them and with others, ECF number 135 at 21 through 26, because the admissibility of these texts turned on trial testimony. I reserve decision for trial. At trial, the text messages were admitted without objection. Then it goes to the defendant's text messages. The government moved to admit the defendant's text message that his world was huge and had many rules. ECF number 135 at 27. The request was granted. It was admissible as a statement of a party opponent. Fed R Evidence 801 D2 and relevant to the enterprise means and methods. Fed R Evidence 401. It was not unduly prejudicial and did not otherwise violate Rule 403. Electronic note. The government moved to admit evidence of an electronic note that Jane Doe number 5 wrote on his cell phone in August 2018 containing a list of defendants' rules. ECF number 135 at 35 through 36. The request was granted. The note was not hearsay, rather it was offered to show evidence of the list and that Jane Doe number 5 authored it. It was also relevant. It went to the enterprise means and methods and the control the defendant exercised over Jane Doe number 5. As Jane Doe number 5 testified, she wrote the note. Thus, the note was admissible to show that she authored the list. The evidence was not unduly prejudicial, nor did it otherwise raise other Rule 403 concerns. Newspaper articles. The government moved to admit certain newspaper articles as ancient documents pursuant to Federal Rules of Evidence 803-16, ECF number 135 at 36 through 38. The article showed that the defendant performed in Macon, Georgia on August 3rd of 1994, in Albany, Georgia on August 31st, 1994, and in Miami, Florida on September 2nd of 1994. The request was granted with acknowledgement that the ruling could be obviated by stipulation by the parties. Ultimately, the government admitted a heavily redacted version of the August 3rd, 1994 article concerning the Georgia's court date without objection. Request to exclude certain evidence.
That was
A,
concert. You said court date.
I'm
Concert.
sorry, concert dates. Sorry. I'll reread that. Ultimately, the government admitted a heavily redacted version of August 13, 1994 article concerning the Georgia concert dates without objection. So the second part of it, request to exclude certain evidence. A, prior conduct of witness. The government moved to preclude the defendant from eliciting testimony or other evidence and from making argument about any victim witness past sexual behavior with anyone other than the defendant or with others at the defendant's direction. ECF number 135 at 3. The defendant did not move Rule 412C to introduce such evidence. Thus, the request was granted. Federal Rule Evidence 412. B. Witness mental health history. The government moved to exclude evidence of prior mental health histories of certain witnesses. ECF number 136 at 9 through 12. The details were submitted under seal. The motion was granted. Although evidence of witnesses' psychological history may be admissible when it goes to his or her credibility, the critical inquiry is the nature of the infirmity and
Crucial.
I can't see. Wait. The crucial, inquiry is the nature of the infirmity and whether the witness suffered from the problem at the time of the events to which the witness is to testify, so that it may have affected the witness' ability to perceive or to recall events or to testify accurately. United States versus Wilson, not 493 F sub 2D 464 467 ED NY 2006. Nothing in the parties' submission showed that any witness mental health history implicated that witness ability to perceive or recall. Evidence
Well,
about
but it could show that they cray cray.
yeah, yeah.
That they're delusional
Wait.
about the relationship. It could
hmm
show that. Come on now.
Evidence about the victim's parents. The government moved to preclude the defendant from introducing evidence that the parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with him. ECF number 135 at 12 through 14. The request was granted in part and reserved in part for trial.
But you see that, right? The government moved to preclude the defendant from introducing evidence that the
That the
parents.
so she granted that.
She. That's why they were saying that the defense couldn't bring certain things. Now you see why all these people putting out these narrative that the defense didn't do anything. The judge stopped them from doing anything. So all these people trying to throw shade at Kanek and his defense team, y'all need to close your ears from these idiots. I'm serious. Okay, sorry.
At the August 3rd, 2021 hearing, the government presented that it did not intend to call any of the witnesses' parents because a parent could not consent to the charged conduct. Questions to victim witnesses about whether their parents consented or permitted the defendant to have sexual contact with them would have been improper. Federal R Evidence 401. However, questioning with a good faith basis about a coordinated extortion scheme was permissible, including for impeachment. Okay.
But did they impeach her? No, they did not impeach her.
Evidence of the defendant's prior good conduct. The government moved to preclude the defendant from introducing evidence of his prior good conduct, including evidence of music awards or honors. ECF number
Okay,
130.
hold on, Tanya. This is I need you to read this one important because I've seen somebody putting some videos up and all this kind of stuff about his defense. Can you please read this again? What the judge said about this, please?
Evidence of the defendant's prior good conduct. The government moved to preclude the defendant from introducing evidence of his prior good conduct, including evidence of music awards or honors. ECF number 135 at 14. Decision was reserved for trial, at which the defendant did not put on character evidence. Although criminal defendants may present evidence of a relevant character trait or reputation testimony, Federal R Evidence 404A, 2A, 405, that evidence may not take the form of specific prior act evidence or evidence that the defendant did not commit bad acts on prior occasions. And it lists the United States versus NS number 18 CR 134 2019 WL 6999912 at 8 EDNY December 20th 2019. Any character evidence must be presented in a permissible form under these rules. Specific prior acts, including awards or honors received, are not generally admissible. At trial, some witnesses testify about the defendant's professional achievements. I ruled that defense counsel's questions about celebrities' presence at the defendant's recording studios were permissible to support the defense argument that certain conduct and protocol the government had elicited testimony about were attributable to security needs. Oh,
Are
wow.
they saying that they wouldn't allow the celebrities in because security?
Yeah.
Okay,
Wow.
all right. Sorry, my bad. I just
Evidence,
trying to
I know,
understand.
evidence of Jane Doe number 8 employment as an exotic dancer. The government moved to preclude the defendant from asking Jane Doe number 8 whether she worked as an exotic dancer years after her encounter with the defendant or about her participation in a lawsuit against the owner of an exotic dance establishment for unpaid wages. The request was granted. At trial, defense counsel asked some of the witnesses questions along these lines. Defense counsel asked the witness about her parents' effort to get the defendant to engage in business endeavors. The evidence was inadmissible. It was not relevant to or probatable of Jane Doe number.
Did y'all hear that, y'all? Did you guys hear that? All those that's been putting out that bull. Oh, he didn't put this. The defendant didn't do this. They didn't do that. They could have brought me on. They could have had me as a witness. Are y'all listening to what the judge ruled? Are you guys listening to what the judge ruled? Because some folks got you guys thinking all kind of cray stuff. All right, but this is what the judge said. This is what she allowed. Okay, all these internet attorneys, internet guru of law. Listen to what the judge said. Okay, should I repeat it again, Ivan? All these super attorneys of law on the internet, you cannot overrule what the judge put in, since you guys think that Kanik and everybody else did such an awful job. And we kept trying to tell you the judge didn't allow this, the judge didn't allow that. But no, y'all want to listen to Cray Cray on the other side. Cray Cray don't know what the hell she's talking about. Y'all keep listening to her. Having people walking down the street looking like apes. Y'all keep listening to her. Okay. All right. Keep doing it. Because y'all going to be in the same place. Keep doing it. Okay. Because she do tapes without putting names in them. We know who she is. Cray Cray. Cray Cray's the law. Saying how much Kanik didn't do his job. Y'all keep listening to that. You're going to be going down that bridge. And this is what the judge said herself. Now I dropped the mic. Boom.
Okay. Defense counsel, I'll go back over that. Defense counsel asked a witness about her parents' efforts to get the defendant to engage in business endeavors. This evidence was inadmissible. It was not relevant to or probative of Jane Doe number eight's truthfulness. See United States versus David. I'll go over that. Precluding evidence that government witnesses worked as government witness
But look at this.
work.
They put the wrong Jane Doe on this. That was Jane Doe number 5, not 8. Ooh,
Well, they're talking about eight as a
as
exotic
well.
dancer.
Okay, okay.
Precluding evidence that the government witness worked at it as an exotic dancer because nothing about the job connotes veracity or lack thereof. Identities of victims witness. The government moved to protect the identity of certain victim witnesses during the trial. ECF numbers 121, 133. Specifically, the government sought an order permitting these victim witnesses to testify using a nickname or their first name, limiting references to each in open court to their nickname or first name, preventing public disclosure via cross examination or otherwise of their prospective addresses, names of family members, or exact place of employment. The government requested that these measures apply to the following victim witnesses. You got Jane Doe's number 2358, Jane Doe 10, 11, 13, and 15, Jane Doe 16, 17, 18, and 20, John Doe 1, and John Doe 2. The defendant did not object to the request with respect to any victim witness except for Jane Doe number 5. The government request was granted. The Sixth Amendment Confrontation Clause protects two primary interests: the defendant's need to investigate a witness and to elicit information that might be relevant to the jury's conclusion about the witness' credibility or knowledge. And those are the case studies. The government must provide a reason for the limitation in limitation it seeks, and the defendant then must demonstrate a particularized need for disclosure. The court weighs the defendant's needs against the risk to the witness.
But here's my thing. I have a problem with that with Jane Doe number 5. Jane Doe number 5 was all over the internet, just throwing negative things about Robert. But meanwhile, he couldn't investigate all this stuff about her background. That is so one-sided and unfair. I don't understand it because she was all over the place showing who she was.
Mhm. The government identified legitimate and compelling reasons for Jane Doe number 5 to testify using a pseudonym. Jane Doe number 5 was expected to and did testify in explicit details about degrading and humiliating treatment, order of motions in limine, and it's got the case studies. I'm going to go, the trial garnered a lot of media attention, and there was a significant risk of humiliation and reprisals. And I'll go to, that's the case
But that
right there.
humiliation came from her. She the one said she ate doo doo
Hmm.
on her live. She said
Hmm.
it.
The reason to limit identifying information about a witness may be that she may be subject to reprisals. The defendant argued that that identifying Jane Doe number 5 publicly and by name would be necessary to his in court and out of court investigation of her, and goes to the heart of her credibility. ECF number 137 at 1 through 3. He further argued that permitting the limitations the government requested would undermine the presumption of innocence. The arguments are undervailing. The defendant did not identify a clear, particularized need to have Jane Doe number 5's name disclosed publicly. The defendant knew who Jane Doe number 5 is and investigated her background, nor was there any need to disclose Jane Doe number 5's identity in order to impeach her. Defense counsel did a thorough cross examination of Jane Doe number 5 about her prior statements without disclosing her name. Finally, the court gave the jury instructions that the use of nicknames or uh, prosonyms is common in cases that have garnered media attention. Wow.
Yeah,
Granting
but she was all over the place. We know her name. Asriel, Asriel, Asriel.
mhm. Granting an application for witnesses to testify using their first name only and explaining that the court will instruct the jury that this is due to the sensitive nature of the conduct the witnesses will describe and the likelihood of embarrassing, oh my God, publicity. In sum, a balancing of risk to the victim witnesses against the defendant's interests support permitting the requested limitations. The victim witnesses testified that humiliating and explicit acts of abuse, some of which took place when they were minors. Conclusion: for these reasons, the motions in limine were granted in part and denied in part. So ordered Judge Ann M. Donnelly.
All
Dated
right.
Brooklyn, New York.
You don't have to do all that. You don't have to do it. What I'm going to do is I'm going to put the link in, and those who wants to come in and comment, please come on in. Let's have a conversation about this. Because I have mine. I have mine. And Flower Pot, go sit down somewhere. And I'm going to continue to call you Flower Pot. I don't care. For spewing all this negativity about the attorneys and all this bullcrap. You and your fake attorney law having degree, blink, 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 blink. A whole mess. Exactly, Fifi. I'm Felicia. Exactly, a whole mess. She got all the degrees, y'all, and no face. But her body's better looking than anybody, and she look better than anybody. She got the prettiest face. She got the because we're ugly. We look like apes. Okay, I'll be an ape, but at least I'm a smart ape. Sorry. Hi, Terry.
Shh. I wanted to say hi to you all. I'm listening and watching. I gotta go. Bye.
Bye. See you later. Terry's sneaking and saying hello. He's at work. He's at the office. All right. Anybody else want to say something? This is just mess, BS mess. Erica, I agree with you too. 100%. This is some BS mess. If she thought they didn't do a good job, why didn't she take her? Exactly, Priscilla. Exactly. But you know what really gets on my nerve? There's people in her chat who really believes the stuff that she's saying. They really believe it. They really do. But this is the explanation of everything happened, why certain things did not happen. The defense hands was tied behind their back. They tied Robert's hand behind his back, as well as the defense. So they did what they could do with the limited amount of stuff that they had. So I'm gonna say kudos out to Kanik and the team, because let me tell you something. They did. I mean, Kanik came on not too long before trial. Y'all, I guarantee you what they put in was definitely uh, um, a reason for appellate court coming in. And let me tell you, Jennifer would have never come in if there wasn't enough evidence to overturn this stuff. Okay, and I know she put out yeah, I do look at your videos because people send it to me. Yes, I do, because I want to see the nonsense that you're talking about. And nobody's stalking you because I don't go on your page. Somebody send me a video and I watch the video. Absolutely. I don't go no IG page of yours. I don't even know where it's at. I'm not even subscribed to your Facebook. So all the extra stuff that you're putting in there, go at it. Have fun, lady. But when you're putting fake information out about the attorneys, I'm going to call you out on it because you don't know what you're talking about. You're just mad because you have no connection with the attorney. That's the problem. You're mad because you don't know what's happening. You're making up stuff and confusing the people out here. I have never seen you put our motion out. I have never seen you gone to the courthouse. I have never seen you do any part of rally, even participate in any rally. You talk a lot of game and there's no action behind your words. And you are confusing the people. And it's sad that the people is allowing you to confuse them, because for some strange reason, folks that want some information, they'll take information from anybody. A person that's not even there, has never been there, you have never seen her. You don't even know who she is. She could be sitting right next to you. But you want to sit there and you want to believe the nonsense because she's such a narcissist. That she looks better than everybody. She smells better than everybody. Her hair is longer than everybody. That's fine. That's wonderful. Wonderful that you got all that going on, but you're spewing false information out there. You're doing that and you're messing up Mr. Kelly's fan base. And it's sad. You're dividing them. It's really sad that they have to go all over the place trying to find information because half of them can't even go to the courthouse. They want to hear what's going on. They want to hear what the motions are. That's what they want. They don't want to hear all this extra stuff. They don't want to hear all that extra stuff. We want to stay focused. We want to know what we could do. What you need to be doing is pushing those petitions out there since you're such a great person of getting government information and knowing the law and all that. So why don't you just push those motions out? I mean, those petition, the petition about the Mann Act, the 1910 White Slave Act. Why don't you push that out? Because there's a couple of motions out there that you need to be pushing instead of this negative talk. Let's focus on that. Get these motions out. Let's get these motions, petitions. That's what I'm talking about, petition. And I was doing some research. Tanya and I was looking at how petitions get signed and brought over to Congress. And I found out that you could at least 20 signatures could get stuff rolling. But if you get more signatures, it moves the representative or whoever it is that you want to do it. That's what we need to be concentrating on. Bringing awareness to Robert's situation, not fighting one another. And I'm saying that because I'm on a good channel. And you guys are right when y'all say I shouldn't go on the other channel and do that. But you know what? Listen, I'm human. But I get back right on track and do the right thing. So y'all, let's stay focused. Let's stay focused as supporters, spreading the word, spreading what's happening. This is the kind of information that we need. We need to stay abreast of what's happening in the courthouse. You have signed everyone that I have signed everyone that said R. Kelly's name on. Oh, good. Thank you, Erica. I got to go, guys. Only. Okay, Sharon, have a good one. Have a good rest of your day at work. We haven't seen the right track on them, period. I have made the judge and jury some. Angela, you're so silly. Rob, stop. I got a call, guys. Kick you out. Okay, I'll just put the link in. All right. Let's see. Yep, everyone wasn't informed already, thought he was guilty by lifetime. Yeah, by all the lies that they were putting out there. Lady J, hit the link. Let us talk here from his queen. Oh, I heard about her putting something out about me. What did she say? What did she say? She had a mouthful to say this morning. She's mad. Let me tell you the reason why this Lady J, whoever she is, Juliet, whoever she is upset. Yes, she did come into my group. Yes, I did, because she was talking all this stuff, and I'm like, this lady, you don't know who the heck she is. Like everybody else, hiding behind these pictures and channel. You never see their face, but then they always having this thing of saying this and saying that. She was saying her king. When she tries to tell me that king, and I said, first of all, I have only one king, and that's Jesus Christ, my Lord. Robert is not my king. I am not a fanatic of Robert Sylvester Kelly. I am a supporter. I didn't even know anything about majority of the music that I've learned about. I learned about, I Believe I Can Fly. I know he's a great musician, a great artist. But as far as me, I've never been to a concert. I'm just going to tell you, I've never been to a concert. I've never, she keeps dropping out. They keep kicking her out. Hold on a second, put it back in there. But and for them to put me as a, because I'm a strong supporter, that I go to all trials and I go to the marches and stuff, because I'm a supporter. Listen, a supporter. Supporter. That means you're going to support regardless of what others are saying. I support him wholeheartedly. I am going to take the time out to bring awareness to people of the things that's happening for him, on to him and about him. That's what I am. If you feel that that makes me a super fan, oh well, that's on you. But I know who I am. I am a supporter. I bring information out to you. I read documents. I have other people reading it for you. Okay, that's what I do. I pray for the man. I fast. That's what support does. Support means to hold this person up when they're down. That's what it's for. Now, on you guys, I might say something different about you, Juliet, whoever you are, Jules, whatever you are, because it seems like you obsess. You're very obsessed. You fighting with somebody named Rachel Warren. You're fighting with Flower Pot. You fight. Oh, I don't understand you guys. I really don't.
It's crazy.
Yeah, she got mad because one day she came in there talking about king this and king that. I'm like, that's not my king. And she's giving me warning that he's never going to talk to me. I'm not here for him to talk to me. No offense. I'm not here for him to talk to me. I'm here to bring awareness and for fairness for his trial and things like that. Because I feel and I believe that he's been done wrong. He was railroaded. He was framed. That's what I believe. That's what I believe. Now, as far as me and being a groupie and all, I've never been to his concert, y'all. I've never been to his concert. And that's a God honest truth. You know, I have people like Miss Fat who teach me about certain things about Mr. Robert Sylvester Kelly. And most of the things I've learned, I've read, I've researched. Now, if that makes me a stalker, oh well. I've never been to his house trying to stalk him. I don't hide in his bushes. I don't climb his fence. I've never done any of that. I didn't even know where he lived until all of this stuff happened. Because one of the rallies, I went on a field trip with the leader, and I went to see where he lived. That was the first time I've ever seen where he lived. And then this last rally, that's where I found out where he lived there. You know, that I've been researching. This is what I've been doing.
And what's understood never has to be explained either.
Exactly. You're right. But they're just making comments and super stuff because somebody sent me her stuff today and I was still listening to it. I'm going to finish listening to her because this Juliet lady,
I know,
don't
right?
know who she is. But, I'm going to go on the backup channel because I am going to play what she said about me because you guys, I need you guys to hear this loud and clear because they mad because someone put down that Joycelyn is engaged to Robert. She's upset because she's the one. Let's go back to the backup channel, guys. I'll see you guys on the backup channel. I don't want to make this channel. My people pulling me for a field trip. Let's go to a field trip, guys. I'll see you later. Other channel.